Hello everyone. I am Dr. Sharad Kumar, Assistant Professor, Department of Wildlife Sciences, Aligarh Muslim University. Drastic increase in pollution of air, water, soil, deforestation, global warming and climate change are leading to environment degradation. The degradation of the environment through various anthropogenic activities is detrimental to the health of all the living organisms, including humans, plants and animals. So, formulation and implementation of laws and policies to prevent environment degradation is very important step for environment conservation. Knowledge and awareness about these laws is important to deal with the issue of environmental degradation. In this lecture, I shall be giving the brief intro of various conservation laws and details of Environmental Protection Act of India. Indian Constitution and Environmental Laws. The Indian Constitution contains specific provision for environment protection under the chapters of Directive Principles of State Policy and Fundamental Duties. The lack of specific provision in the Constitution recognizing the fundamental rights to clean and wholesome environment has been set off by judicial activism in India. Different articles related to environment. Article 21, Right to Life, which is amended by the Supreme Court of India as the right to healthy environment. Article 21 of the Indian Constitution guarantees a fundamental right to life and personal liberty, and the Supreme Court has interpreted the right to life and personal liberty to include the right to natural, clean and healthy environment. The Supreme Court, through its various landmark judgments in the field of environment, have held that the mandate of right to life includes right to clean and healthy environment, drinking water and pollution-free atmosphere. Article 47 state that as its primary duty, a state is to ensure raising in standard of the living people, to increase the nutritional level of the people, to bring improvement in public health. All these make it mandatory for the state to ensure the environment conservation for the people of India. Article 48A said that a state shall endeavor to protect and improve the environment and to safeguard the forest and wildlife of the country. The rights and duties of a person are correlative. Initially, the Indian Constitution contained only fundamental rights. It was after the 42nd Constitutional Amendment Act 1976 that the fundamental duties were incorporated in the Constitution. Clause G of Article 51A imposed a duty upon the citizens of India to protect and improve the natural environment, including forest, lakes, river and wildlife, and to have compensation for living creature. With the collective effect of Article 48A and Article 51AZ, it appears that both state as well as the citizens are now under constitutional responsibility for the protection and improvement of the environmental conditions of India. The words protect and improve appearing in both these articles seems to reflect an affirmative action to improve the quality of environment and not just to preserve the environment in its polluted form. Means if environment is polluted, it is the duty of the state and citizens to take all action to get rid of the pollution. Laws for environmental conservation in India. Indian government enacted several laws and rules in India for the conservation of environment. Some of the important laws are the Wildlife Protection Act 1972, the Water Prevention and Control of Pollution Act 1974, Forest Conservation Act 1980, the Air Prevention and Control of Pollution Act 1981, the Environmental Protection Act 1986, National Environmental Tribunal Act of 1995, Biodiversity Act of 2000, National Tribunal Act 2010. Now, let's discuss in detail about the Environmental Protection Act and Rules 1986. Period of 1970s experienced global increase in industrialization and intensification of agriculture, leading to degradation of the environment at a very high pace. The need was felt for a combined effort towards environment conservation from all over the world. A result of these combined effort was the United Nations Conference on the Human Environment, the Stockholm Conference 1972, which was held from 5th June to 16th June in 1972. In India, the Bhopal gas tragedy of 1984 called for urgent legislation in the field of environment. In this background, the Parliament passed the Environmental Protection Act 1986 and the Environment Protection Rules 1986. Genesis of Environmental Protection Act. The root of the enactment of the Environmental Protection Act lies in the United Nations Conference on the Human Environment. The focus of this conference was the state of the global environment and the relationship between economics, science, and the environment in a political context. India played a very significant contribution role in the conference. India participated and assured world to take appropriate steps for the improvement of the human environment. The emphasis was on solving environmental problems, but without ignoring social, economic, and development policy factors. This conference laid the foundation of environmental legislation in India. The Act implements the decision made at the Stockholm Conference, and Environmental Protection Act came into force on November 19, 1986, and it extends to the whole of India. Salient features of the Environmental Protection Act. It is the Act deals with criminal jurisdiction of activities leading to environmental degradation. The Act makes central government most powerful in dealing issues of environment conservation. Environmental labs are established or authorized by the central government, state government, central pollution control boards, or the state pollution control boards to check the level of pollution in various industries or in various areas located around industries. Under the Act, standards are laid down by the central government. The Act also seeks stringent penalties and punishment for violation of the rules which are framed under the Act. The Act said that for the violation of Act, person having highest authority is prosecuted. The Act's locus standi is very relaxed, and any person can file a case for violation of Act. The Act is also applicable to government department, and if some government department is found of violating the rules of the Environmental Protection Act, then the head of the department is responsible for the same. The Environmental Protection Act is umbrella legislation, and it provides the opportunities to formulate various rules for environment conservation. Following are the objectives of the Act. The Act was passed to provide for the protection and improvement of environment and for matters connected therewith. The Act gives certain power to the central government to take measures for the purpose of protecting and improving the quality of environment and to prevent environmental pollution. The Act is an umbrella legislation designed to provide a framework for central government coordination of the activities of various central and state authorities established under the previous laws such as the Water and the Air Act. Let's discuss the Act in detail. Chapter 1. The first chapter of the Act is entitled Preliminary, and it deals with the short titles, extent and commencement and the definitions of the various terms used in the Act. Section 1 of the Act deals with short title, its extent and the commencement. The Act may be called the Environmental Protection Act 1986. It extends to the whole of the India and it shall come into force on the such date as the central government may by notification in the official gazette. Section 2 of the Act deals with the definition of the various terms used in the Act. Some of the important definitions provided in the Act are: environmental pollution means the presence in the environment of any environmental pollutant. Handling in relation to any substance means the manufacture, processing, treatment, package, storage, transportation, use, collection, destruction, conversion, offering for sale, transfer or the like of such substances. Hazardous substance means any substance or preparation which by reason of its chemical or physiological chemical properties or handling is liable to cause harm to human beings, other living creatures, plants, microorganisms, property or the environment. Chapter 2 is entitled as General Power of the Central Government. Section 3 of the chapter 2 deals with power of central government to take measures to protect and improve the environment. It is stated that central government has power to take all necessary measures for environment protection, coordinate the action of state governments, lay down standard of environment quality and pollutant, execute nationwide programs for environment conservation, restriction of areas for industries, inspecting industrial premises for any impact on environment, and issue order to take corrective measures by the companies or the industries, preparation of manuals, codes or guides to guide the people who are responsible for implementation of the various functions of the Act. Section 4 of the Act deals with appointment of officers and their powers and functions, and it states that the central government may appoint officers and entrust them with such powers and functions as it may deem fit for the purpose of the Act. Section 5 deals with the power of central government to give direction. In the Act, central government is most powerful and central government is empowered to issue direction to any person, officer or any authority, closure, prohibition or regulation of any industry, operation or process leading to environmental degradation. It also provides power to disconnect electricity and water supply for polluting industries. Section 6. Rules to regulate environmental pollution. Section 6 deals with rules to regulate environmental pollution, and it states that central government is empowered to make rules to regulate environmental pollution on the following matters: standards of quality of air, water or soil, maximum allowable limit of pollutants, procedure for the handling of hazardous substances, prohibition and restriction on the location of industries, procedure and safeguard for the prevention of accident. Chapter 3 is entitled as Prevention, Control and Abatement of Environmental Pollution. Under section 7, the Act talks about prevention of environmental pollution and state that no person carrying on any industry, operation or process shall discharge or emit or permit to be discharged or emitted any environmental pollutants in excess of such standards as may be prescribed in the Act. Section 8 states that no person shall handle or cause to be handled any hazardous substance except in accordance with such procedure and after complying with such safeguard as may be prescribed. Section 9 provides the procedures and processes are laid down to control pollution in case of environmental degradation. Section 10 deals with monitoring authority carrying out inspections of the various industries. Section 11 empower the authorities to take samples as prescribed by the procedure given in the Act. Section 12 provide for these samples are tested in the environmental laboratories established by the or recognized by the central government. Section 13 deals with the government analyzed. So under this section, central government may by notification in the official gazette appoint or recognize such persons as it thinks fit and having prescribed qualification to be government analyzed for the purpose of analysis of samples of air, water, soil or other substances sent for analysis to any environmental laboratory established or recognized. Section 14 reports of government analysis, and it states that any document purporting to be a report signed by a government analyst may be used as evidence of the facts stated therein in any proceeding under this Act. Penalties and punishments. So under the section 15, whoever contravenes the provision of the Act, a maximum punishment up to 7 years and penalty up to 1 lakh or 5,000 per day for the continued offences. Under section 16, for defaulter companies or body corporates, director or partners are prosecuted. This Act is also applicable to the government department, and HOD is prosecuted if some government department is found of violating the rules of the Act under the section 17. Chapter 4 Miscellaneous. Protection of action taken in good faith is under section 18, and it states that no suit, prosecution or other legal proceedings shall be lie against the government or any officer or other employee of the government or any authority constituted under this Act or any member, officers or other employee of such authority in respect of anything which is done or intended to be done in good faith in pursuance of this Act or the rules made or orders or direction issued thereunder. Section 19 Cognitions of offences. It states that No court shall take cognizance of any offence under this act except on a complaint made by the central government or any authority or official authorized in this behalf by that government, or any person who has given notice of not less than 60 days in the manner prescribed. No civil court shall have jurisdiction to entertain any suit or proceeding under this act. Section 23 deals with the powers to delegate, and section 24 deals with effect of the other laws. Section 25, powers to make rules. So it provides the powers to the central government to make the rule for the environment conservation. And section 26 empower central governments to make rules, and these rules should be laid before the parliament. So we can say that this is an umbrella legislation, and there are several rules are framed under the Environmental Protection Act. Few of the important rules which are framed under the umbrella of the Environmental Protection Act are Environmental Protection Rule 1986, Hazardous Waste Rule 1989, and now 2016. Biomedical Waste Rules 1998, Municipal Solid Waste Rules 2000, Noise Pollution Rules 2000, Ozone Depleting Substances Rules 2000, Battery Waste Rule 2001, Plastic Waste Rules 2011, Electronic Waste Rules 2011. Now have a brief introduction of the Environmental Protection Rules 1986. These rules lay down further details for implementation of the Act, and it provides standards for emission or the discharge, etc. Procedure laid down for giving direction under Section 5 by central government. It also prohibited and restricted on locations based on proximity to human settlement, ancient monuments, biodiversity. So the rules are restricting the operation of the various industries close to the human settlement, biodiversity sites, and the ancient monuments. It also provides the direction to follow the procedure to take samples, and when any person is filing complaint, format of notice and details about whom to serve the notice, etc. It also provides the format of environmental lab reports. It also provides the format of environmental audit. There are schedules under the Environmental Protection Rules 1986. So Schedule 1 lays down the procedures and standard for 87 different industries. For example, rubber, copper, iron, and cement factories. Schedule 2 lay down the standards for the noise. Schedule 3 talks about the standards for motor vehicles. Schedule 4 talks about the general standards for effluents, inland surface, public sewer, land of irrigation, marine coastal areas, etc.